Hello, everyone, and thank you for joining today's briefing. I'm AJ Hikes, your Deputy Executive Director for Strategy and Culture at the ACLU, and I am always so grateful to be in space with our ACLU community. Today, we're here to discuss the Supreme Court's latest term, which ended on Friday. During this term, the court handed down rulings that directly impact our civil rights and civil liberties, including deeply disappointing decisions on gender-affirming care and free speech. I will repeat to you, our supporters, what I have repeated to the staff at the ACLU many, many times. We may be devastated, but we are not deterred. We may be bruised, but we are far from beaten. And most importantly, we have each other's backs. We are not stopping anytime soon. So this briefing is our opportunity to come together as a community and to break down the major decisions and talk about what lies ahead. And we're going to get into all of it. I want to first name that many things can be true at the same time. We can be disappointed by the Supreme Court, but we can also see the promise to defend, protect, and ultimately build our rights inside and outside of the court. We have no other alternative but to fight, my friends, and to demand more. And we will do that, and we're going to do it with all of you. So over the next hour, you're going to hear from our ACLU legal experts about what the Supreme Court's decisions mean for our civil rights and civil liberties, what the path forward is, and of course, how you, our incredible supporters, can stay involved and take action. Now let's start this very important conversation with the ACLU's National Legal Director, Cecillia Wang.
Hi, AJ.
Thank you so much for joining us, Cecillia. I hope you're holding up, my friend.
I'm holding up fine. Hope you
All
are.
right, I'm glad to hear it. I'm glad to hear it. Now, before we dig into the details, I'm hoping that you could just set the scene for us and place the ACLU Supreme Court docket into context. Can you tell us how many of our cases, either as direct counsel or a friend of the court, were before the court this term? And then how do they fit into the ACLU's larger legal fight for civil rights and civil liberties?
Sure, AJ, I'm happy to. So first, let me give our listeners the ACLU's term at the Supreme Court by the numbers. The ACLU had 3 cases in front of the Supreme Court this term. We filed 11 amicus briefs or friend of the court briefs in other cases. We had 5 cases plus 1 amicus brief on the court's emergency docket, which you might have heard referred to as the shadow docket sometimes. We filed 10 petitions asking the court to take a case, and we opposed someone else's cert petition in 8 cases where we won in the lower courts. I can give you 3 takeaways about the term overall. The first is that I think this is a term where we really saw the 6-3 conservative majority on this Supreme Court flexing its power and delivering some really terrible losses on key civil rights cases. Second, however, we did score many important wins in lower profile cases on behalf of civil rights plaintiffs or criminal defendants who were asserting their due process rights. And then third, the court's emergency docket, the so-called shadow docket, is increasingly important and in many ways eclipsed the cases the court decided this term on its merits docket. And particularly, we saw that in cases involving challenges to the Trump administration's illegal actions. And we'll talk about that today.
Great. Thank you so much for breaking that down for us and setting the stage, Cecillia. Let's start by talking about one of the cases that made real headlines, birthright citizenship. So long before the court's decision, we were already fielding a lot of questions about the judiciary's ability to maintain and enforce the rule of law. So can you share your perspective on the court's decision on Friday with these concerns in mind?
Sure. The case is called Trump versus Casa, and this was a series of 3 consolidated lawsuits in which 22 states, various nonprofit organizations, and individual expecting parents sued the Trump administration's executive order that purports to undo the 14th Amendment's guarantee of birthright citizenship. So just to recap for those who haven't been following closely at home, on Inauguration Day, President Trump issued an executive order that is really an attack on our Reconstruction Constitution, and specifically the post-Civil War vision of equal U.S. citizenship for all, regardless of your previous condition of enslavement, your race, or your parents' national origin. And Trump's executive order goes against the text, purpose, and history of the 14th Amendment, the Supreme Court's 1898 decision that confirms birthright citizenship following the 14th Amendment's ratification, and a statute that Congress enacted to codify the birthright citizenship guarantee in federal statutes. So Trump's executive order would deny U.S. citizenship to babies born to immigrant parents who do not have lawful status or who have lawful status but temporary status in the United States. The ACLU sued within 2 hours in New Hampshire on behalf of community-based organizations and expectant parents. And we were among dozens of lawsuits that ended up being filed challenging Trump's executive order. Every single lower court that dealt with this executive order blocked it, held it was likely unconstitutional, and issued a preliminary injunction. This brings me to the Trump versus Casa case that you're asking about. Trump versus Casa, I want to emphasize, does not deal with the constitutionality of Trump's executive order. Instead, the Trump administration filed an application with the Supreme Court asking it to put on hold or freeze these lower court decisions that had blocked the executive order and that said babies born in the United States to these immigrant parents will be counted as U.S. citizens. The Trump administration went into court on this very narrow theory about so-called nationwide injunctions. Basically, their theory is that district courts, federal district courts, should not issue injunctions that protect anyone other than the plaintiffs who brought the lawsuit. This comes up frequently when there are cases challenging the federal government's actions or policies, because normally when a federal court says that a government action is unconstitutional, government officials comply with that, including with respect to people who weren't plaintiffs in the case. So Trump went into court saying, please freeze these lower court orders to the extent that they protect anyone other than these 22 states and these particular plaintiffs. Now, the Supreme Court really went out of its way to reach that question of nationwide injunctions totally unnecessarily in this case, because the 22 states and the other plaintiffs in these cases made a strong showing that in order to get complete protection, in order to guard their interests against this unconstitutional order, the lower court's decisions really needed to apply around the country. You can't have a patchwork where babies born in these 22 states are US citizens and the babies born in all the other states aren't. And yet, in a majority decision by Justice Barrett, the Supreme Court went out of its way to disapprove of nationwide injunctions. But I want to be really clear about a couple of things. The first is that this order not only doesn't touch the constitutionality of the birthright citizenship order, but also leaves the injunctions that block Trump's birthright citizenship order from going into effect for at least 30 days. So babies born around the country will continue to be US citizens. And the Supreme Court sent all of these cases back to the lower courts, letting them potentially reissue the same injunction orders that take the Supreme Court's concerns into account. And I'll finally say that within 2 hours of the Supreme Court's decision in Trump versus Casa, the ACLU was back in court filing a brand new proposed nationwide class action lawsuit in order to try to get nationwide protection against Trump's illegal order.
Thank you so much for that breakdown, Cecilia. And I love that we are already back in court and back at it. I was wondering if you wanted to lift up a little bit about our Alien Enemies Act case and some of the wins that we saw there.
Sure. So this term is in the Supreme Court is one where over the course of the term from October until the end of June, we saw the Supreme Court really holding firm as a check on the worst executive branch abuses by this Trump administration. This happened in 2 cases that we have challenging Trump's invocation of the Alien Enemies Act. This is a 1798 statute that gives the president certain powers during wartime to detain and deport non-citizens who are nationals of a country the U.S. is in a declared war with. I think everyone probably knows Trump has been using this Alien Enemies Act in a context Congress never meant it to apply in order to try to detain and deport Venezuelan nationals who have been in the United States, many of them legally, many of them applying for asylum, and he's trying to deport them to this gulag in El Salvador, the CCOT prison. We had two of our cases go up to the Supreme Court over the course of the term, first on the Trump administration's application for an emergency order, and then secondly, in one of our cases where we were the ones seeking the Supreme Court's emergency protection for our clients who ICE had given notices to, saying that they would be deported under the Alien Enemies Act within 24 hours. In both of those cases, the Supreme Court rejected the Trump administration's extreme and incorrect legal arguments that the federal courts do not have the power to even touch or review the president's decisions having to do with the Alien Enemies Act, and the courts reinforced our clients and everyone's due process rights to have their day in court in order for the courts to decide on the legality of what the Trump administration is trying to do.
Thank you so much for that breakdown, Cecillia, and for always reminding us that progress is still possible and we are going to continue fighting. As usual, I have to thank the Herculean work of the ACLU's legal team, which is the best of the very best. I know, I feel like I'm the biggest fan of our legal team, Cecillia, but you probably have me beat out. So I'll take the second, the second slate slot. As everyone watching today has seen, the ACLU has not backed down against the Trump administration's attacks on our rights. Far from it. We're not going anywhere. Defeat, dilute, delay. That is our motto here at the ACLU during this time, to lessen the harm of the Trump administration's unconstitutional policies at every level and wherever possible, block them entirely. And so it's all about persistence, doing everything we can every single day to hold the line on liberty. But it's also about sustaining this fight for the long haul. And so I'd be remiss if I didn't give a shout out to our MVPs who are doing exactly that, our monthly sustainers. Y'all resource this fight day in and day out. And so I want to encourage everyone watching to start a monthly gift if you haven't already. You can go to aclu.org/go monthly. And it really is the most important way that you can ensure the ACLU remains at the forefront of this fight for the values that we hold most dear. We ain't backing down, y'all, and especially in defense of our trans and non-binary communities. Speaking of which, I want to call in Chase to discuss the Skrmetti case with Cecillia. All right, Chase. Hello, my friend. I mentioned at the top of the hour that the Supreme Court had handed down a deeply disappointing decision in our case involving gender-affirming care with U.S. versus Skrmetti. But I want to be clear. You have said this a million times, I'll repeat it, that no matter what the Supreme Court says, our commitment to trans justice has never and will never waver. A world without trans people has never existed, and it never will. So we're going to get into the details of this case. I am very honored to introduce my friend and colleague, Chase Strangio, who is the co-director of the ACLU's LGBTQ and HIV project. Chase, I have to give you your flowers, my friend. My deepest gratitude goes to you, and all of our deepest gratitude goes to you and the entire LGBTQ and HIV project for putting your heart and soul into this case. One of the proudest moments I've had here at the ACLU was witnessing you deliver oral arguments before the Supreme Court. We are so lucky to have your brilliance at the ACLU, and your unwavering commitment to fight for the dignity and equality of all trans people inspires me every day. So Chase, there is no question that the decision in this case was gutting, but the Supreme Court's decision did not end constitutional protections for trans people, correct? I know there's a lot of fear and confusion out there, so can you share what the decision actually means?
Yeah, thank you, AJ, and thank you to our fearless leader, Cecillia. It's always great to be here with you both and with everyone joining. So I want to say it's really important that we reinforce that even though Skrmetti was undeniably a devastating decision, and most especially for trans young people and their families, the court did not and could not end the fight for trans justice. So we want to just start there. The court did, unfortunately, allow Tennessee to continue to override the aligned judgment of adolescents, their parents, and their doctors when it comes to available medical care to treat adolescents with gender dysphoria. And this law in Tennessee has forced hundreds of families, including our clients, to uproot their lives in order to maintain health care for their children. I know any parent can understand that when your child is suffering, you are suffering. That is the consequence of laws like this. But the Supreme Court did not end constitutional or federal civil rights protections for trans people. Strong decisions remain in place, including lower court decisions holding that discrimination against trans people is constitutionally suspect. So it's very, very important. There's a lot of reporting saying that Scrimetti ends the constitutional fight for protections for trans people. That is not accurate. The Scrimetti decision also did not disturb the Supreme Court's 2020 decision in Bostock, holding that discrimination against LGBTQ people in employment is impermissible sex discrimination in violation of Title VII of the Civil Rights Act. And importantly, earlier this term, the court unanimously reinforced that Bostock remains good law. And lower court decisions applying the Supreme Court's logic in Bostock remain in place in other contexts like schools and healthcare protections. And those are still good law under federal statutes and under court decisions interpreting federal statutes. And so the Supreme Court got it wrong in Scrimetti. And as Justice Sotomayor said in her dissent, they had to distort logic and precedent to do so. But this misguided opinion does not end our advocacy on behalf of LGBTQ people under federal law, under the Constitution, or under state law. Our litigation against the federal government's policies targeting trans people will continue. The court did not do away with our theories challenging, for example, the State Department's policies of requiring a person's passport to list their sex assigned at birth, or the president's executive order attempting to coerce hospitals and healthcare providers to stop providing gender-affirming medical care for trans adolescents under the age of 19. And the decision in Scrimetti does not change the more than half the states in this country that do not ban medical care for trans adolescents. It does not require those discriminatory laws. It simply permits Tennessee's to remain in effect. So the fight continues. We continue our advocacy on behalf of our community.
The court cannot end the fight for trans justice. If anything, we are going to fight even harder. Thank you for reminding us the Bostock still remains good law. Thank you for all those reminders, Chase. It is so important to remember that the fight isn't over and we have so many other tools at our disposal. Cecillia, another case that touched on the rights of LGBTQ people is Mahmoud v. Taylor. Can you explain that case and its repercussions for LGBTQ equality?
Sure. So the issue in Mahmoud versus Taylor is not LGBT rights explicitly. Rather, it's about the free exercise clause of the First Amendment. Mahmoud is another case that really is devastating for civil liberties, in particular, the balance that the Supreme Court previously has struck between individuals' religious liberty and the ability of government entities to run the government and to apply laws that are non-religious and that apply to everyone in a general way. So in Mahmoud, the court for the first time has given parents who have religious objections the right to opt their children out of portions of a secular public school curriculum. That is, parents can now pick and choose which parts of the school day their children need to sit through based on their religious objections. Ironically, this is a case in which the school curriculum's purpose is to foster inclusive learning and to help students learn to work across differences. This decision in Mahmoud was a break from long-standing precedents on the free exercise clause that have until now held that government entities may enforce religion-neutral laws that apply to everyone. Now, here's why it implicates LGBT rights, and that's because of the facts in the case. Mahmoud versus Taylor is a case where the Montgomery County, Maryland school district implemented an English language arts curriculum that had as one of its main purposes, again, fostering an inclusive learning environment for all students. And they looked at their English language curriculum and decided there were major groups of students that were represented in their diverse school district that were not represented in the curriculum or in the materials that are used in their English language classes. One of those communities that they identified as being underrepresented in the curriculum was LGBT communities. And so the school district implemented age-appropriate materials in the K through 12 schools, including, for example, a book called Uncle Bobby's Wedding, which is an age-appropriate book for elementary school age kids that simply features gay characters. And it's about a young girl, the main character, who is anxious about her uncle's impending marriage because she is afraid that he's going to not have any time for her anymore. So themes that are common in elementary school materials and simply have LGBT characters in them. Initially, the Montgomery County School District permitted parents to opt their children out when books like Uncle Bobby's Wedding were being read, both for religious reasons and for non-religious reasons. As it turned out, that permissive opt-out system resulted in rampant absenteeism, and the school district found stigmatized LGBT children and kids with LGBT parents or other family members. And so the school district said, we're changing our policy. Nobody can opt out. Everybody's got to come to school and sit in the classroom when we're discussing these materials. The Supreme Court sided with the parents in a decision that really expressed Justice Alito's viewpoint on marriage equality and transgender people. And I won't offer my own comment on Justice Alito's opinion, and instead will offer you Justice Sotomayor's dissenting opinion, which said the majority's myopic attempt to resolve a major constitutional question through close textual analysis of Uncle Bobby's Wedding also reveals its failure to accept and account for a fundamental truth: LGBTQ people exist.
Oh, Cecilia, this case is particularly upsetting. Religious freedom shouldn't force public schools to exempt students from any secular lessons. And as we know, this decision could just wreak havoc on public schools and leading to the ostracizing and stigmatizing of LGBTQ people and families. Thank you for breaking that down for us. Chase, I'm going to turn back to you. I am always grateful for your reminders that no matter what, we have work to do, and we're going to keep fighting for our communities moving onward. So I'm going to ask you what activists and advocates are asking all over the country. What comes next? Where do we go from here?
Well, yeah, so I wanna say where we're gonna go, but to do that, I want to look back a little bit because I think we need some perspective. And what comes next is that we continue fighting for justice as we always have. And often people talk about how rapid the LGBTQ movement has been able to, how rapidly we've been able to achieve successes. But it really depends where you start the timeline, how rapid it feels. The ACLU, we've been fighting for LGBTQ rights since the 1930s. In 1986, the year that the LGBTQ project started at the ACLU, the Supreme Court upheld bans on criminal bans on same-sex intimacy. In 1996, after initial successes in state court challenging bans on marriage for same-sex couples, Congress passed the Defense of Marriage Act, limiting the definition of marriage for federal purposes to one man and one woman. In the first decades of the 2000s, state after state passed constitutional bans on marriage equality. When I was first working on marriage equality movement work in 2004 through 2007, we were told that we were getting ahead of public opinion, that we were costing elections through our advocacy, very similar to the refrains that we hear now when it comes to advocacy on behalf of trans people. But constitutional litigation is about protecting minority groups from majoritarian discrimination. It's about protecting principles so the government cannot use a disfavored group to erode rights for everyone. And the fight for justice, it requires endurance and a commitment to fighting for what is right. So when we think about what we are doing moving forward, we're doing what we have always done. We continue to fight for what is right, what is just, against the backlash to our successes on marriage equality, and to think to Justice Sotomayor's dissent in Mahmoud, to fight back against the backlash globally to a more inclusive world. We did not bring, as trans people, a fight over our lives, our bodies, and our healthcare. It was waged on us and on our bodies. So what do? We fight back. We're litigating in state and federal court. We're advocating in Congress and in state legislatures. And importantly, we're building with all of you power for our communities. That is the project moving forward.
All right. Yes, Chase. Oh, this fight was waged on us, and we are going to fight back always. Thank you again so much, Chase. Cecilia, thank you for your insights. No matter what the courts say or how hard the Trump administration may come after our rights, trans and non-binary people are not going anywhere. LGBTQ people are not going anywhere, and neither is the ACLU. To everybody watching, if you're ready to turn your passion into action, if you want to have each other's backs, you can sign up for our new ACLU People Power training series called Organizing to Protect Democracy. The kickoff session is actually a week from today on July 8th. This is the first session in our free, high impact virtual training series built to ignite your activism and give you the tools to organize, to mobilize, and lead in this critical moment. Our folks have been asking for this again and again, so we are excited. We are excited for this. Our communities need bold action. We need you in the fight. So please do join us July 8th, 8 p.m. Eastern by signing up now at aclu.org/PP series, People Power Series. All right, y'all. Thank you so much for that segment. We are going to talk about the power of protest, of dissent, of continuing to raise our voices. So I want to get into this with Ben Wizner, who is the director of the ACLU's Speech, Privacy, and Technology Project. Ben, it is so good to have you with us. All right. So big picture, Ben, can you share how the Trump administration is coming after our free speech rights and what role the courts are playing in this fight?
I can, thanks. Sorry, I was on mute for a second there. I think the irony is that candidate Trump ran on a platform of free speech. And on his first day in office, we've forgotten this. He actually signed an executive order purporting to end federal government censorship. But apparently, what Trump means about free speech is that he and his supporters should be able to say whatever they want online without being criticized. Because as soon as they have power in their hands, they have unleashed the most comprehensive censorship program that I've seen in my entire lifetime. They're using every organ of government power to go after every possible place of dissent in our society. And so we're seeing unprecedented attacks on the independence of universities, where the Trump administration is saying we will cut off billions of dollars in your funding unless we can take over your curricular decisions, take over your hiring decisions, take over your admissions decisions. We're seeing attacks on independent practice of law, on law firms, where the Trump administration is saying that law firms will be subject to a series of penalties and punishments unless they essentially go down to Washington and kiss the ring because they have lawyers in their firms who have challenged, I wouldn't even say government policies, but I would say Trump's individual prerogatives. We've seen attacks on independent scientific research where the government is systematically censoring scientific research that dares to mention words like LGBT or transgender. We've seen attacks on the arts, where in order to get federal arts funding, you have to do the same thing. You have to denounce so-called gender ideology. Most shocking, we have seen armed, masked agents in the street. Pushing people into vans, flying them off to dungeons in other states because of their political speech, because they dare to write an op-ed that was out of line with the administration's policy. Now, the good news is everything that I just mentioned has been challenged by the ACLU and others, and we are winning these cases across the board. We represent 4 non-citizens who were locked away for their political speech. I can report today that all 4 of them have been freed by federal judges as a result of the ACLU and our litigation partners here. We're continuing to fight for them. Those cases aren't over. We saw recently Trump sending the military into the street in a way to chill protests. So there's a lot of work to be done, but our work is working.
Thank you. Thank you, Ben. There was an important free speech case before the Supreme Court this term. So can you break down what the Paxson case was about and how it impacts our rights?
Yes, I will. And this is an issue that the ACLU has been involved in for many decades. And the question is, how far can the government go to restrict the free speech rights of adults in the name of protecting children from viewing sexual content, in this case, online? And there have been a series of government efforts, very crude attempts by Congress over the years to essentially censor the internet in the name of protecting children, turn the entire internet into a sandbox because some kid somewhere might see something naughty. And until now, the Supreme Court has been very clear that while the government has a legitimate interest in preventing children from seeing very sexually explicit content that the children themselves may not have a right to see, it can't do so at the expense of adults' rights. And here we're not just talking about pornography. We're talking about adults who have many reasons for needing to view sexual content. It might be sexual health information that's important. And of course, we heard from Chase and Cecillia, many government actors view any content that mentions LGBT life as being pornographic. We've seen censorship of drag shows under the name of protecting children from obscenity and pornography. So this is a broad power. Until this week, if the government wanted to restrict access, in this case, the state of Texas said, essentially, we're going to card everybody who goes online to look at sexual content. And not just flashing your ID at the door. You need to put your ID, your name, your identifying information into a government database if you want to view lawful sexual content online, so we can verify that you are over 21 years old. In the past, if the government wanted to pass a law like that, the court said, you have to show us that this is the narrowest way of achieving your goal of protecting kids. Here, it clearly is not, because Texas's law only gets at a portion of sexual content. Kids will still be able to see it, and it does so at the expense of adults being able to access that material. And I think what the Supreme Court has really done is it has sort of made what it would call a pornography exception to the First Amendment. Our concern is that lots of valuable speech about sexuality, which again should enjoy full constitutional protection, is now going to be, if not off limits to adults, at least it will deter many adults from viewing that information because they have very legitimate concerns about typing their personal information into a government database before accessing it.
Thank you so much, man. I really appreciate you breaking down the implications for our free speech rights. Ben, I also want to lift up this huge success that you mentioned just a moment ago about all 4 students that we were working on behalf of or have been freed by federal judges. We know the work still continues there and there's a lot more to do, but we have to be taking these moments to really lift up those successes as they come. So amazing. Just congratulations to your team and all of our partners in that work. So I'm going to bring back Cecillia and ask you both a question. As we look to the Supreme Court's next term, what are some of the major cases that we should be looking out for? Cecillia, perhaps we'll start with you.
So people who are listening very carefully, here's a test. I said we had 3 merits cases in the court this term. We've only talked about 2, Scrimetti and Paxton. The third one is the one to look out for first for next term, October term 2025. And that's a case of Louisiana versus Calais. This is a case with an unusual lineup. The ACLU and LDF are alongside the state of Louisiana in defending the congressional redistricting map for the state of Louisiana. To give you a little bit of background and tease the argument that's been reset for next October, the case is one in which the ACLU and LDF, shortly after the Louisiana legislature drew a new congressional redistricting map in 2022, challenged that map under Section 2 of the Voting Rights Act in a federal lawsuit in Louisiana, arguing that the map, which had only 1 district in which Black voters had a fair shot at electing their candidate of choice to Congress, diluted Black voters' political power in violation of the Voting Rights Act. We won a preliminary injunction in that case, which is called Robinson. And for the first time in a long time, Black voters in Louisiana had 2 opportunity districts where they could elect their candidate of choice. And Louisiana indeed did send 2 Black representatives to Congress in the next election. Now, what happened in this case is that a group of self-described non-Black voters brought a lawsuit in a different federal district court in Louisiana to challenge that map that the Louisiana legislature drew as a remedy for the Voting Rights Act violation that we proved in the Robinson case. That case was argued earlier this term, and as we were looking on the last day of the term, last Friday, for a decision, we were disappointed because the Supreme Court said they're going to punt the case to next term, and we expect them to issue a list of questions that they want our side and Louisiana and the plaintiffs in that case to answer in a second argument. So look out for that one, Louisiana versus Calais.
Thanks, Cecillia. All right, Ben, let's turn to you. What should we be looking out for the next term?
Well, Cecilia mentioned the Alien Enemies Act litigation before, and we can be sure that that litigation will find its way back to the Supreme Court. Remember, as Cecilia said, on the so-called emergency docket, the Supreme Court has already rejected the most extreme argument that the Trump administration put forward, which is that the president's power to decide that we're at war with a Venezuelan gang is unreviewable by courts. The court emphatically rejected that position. But now the question will be, well, really, possibly two questions. Let's hope one. The first is, has the Trump administration validly invoked this 18th century statute that's supposed to be about armed conflict with foreign nations to apply to a Venezuelan gang that many people listening to this broadcast had never heard of before Trump's order? Are we really at war with this gang? If not, if the Alien Enemies Act was not validly invoked, then that should resolve the litigation. Even if the court says we have to defer to the president's judgment that we are in an armed conflict, the next question is, what process is available to people who are swept up under that authority for them to say, I'm not actually a member of that gang? And we know from our own investigations, as well as from the New York Times and others, that an incredibly high percentage of the men who were flown down to that awful prison in El Salvador have no ties to this gang whatsoever, but might have been wearing the wrong T-shirt or had the wrong tattoo and ended up being swept up into this. So we will certainly see the Trump administration's attempt to use the Alien Enemies Act before the court again. I would not be surprised if the government tries to bring one of these student deportation cases to the court. Again, the question there is, can the Secretary of State say about any non-citizen in the country, including the 12 million non-citizens here who are legal permanent residents, your speech has interfered with our foreign policy such that we can strip you of your legal status and remove you from the country. It's a kind of claim that we never thought that we would see in this country so far. The courts have pretty emphatically rejected that claim, but we can expect the Trump administration to try to bring that issue before the Supreme Court as well.
When we say the work continues, this is what we mean. We are just getting started. We have major cases on the horizon impacting voting rights, immigration, the right to due process, trans justice, potentially free speech in our student deportation cases, and certainly much more. So keep your eyes peeled, folks. Much more to come. Now, before letting everyone go, because we are coming up on our time here, I would love to bring back Chase, and I would love to ask you all just one kind of final question here. What is one thing that we can do? We have been spending this time talking about the courts, but we constantly remind ourselves that the power of the people is always greater than the people in power. So what is in our power? Ben, perhaps I'll start with you.
Yeah, I would love to start. I mean, it was only some days ago that we saw 5 million of our fellow citizens in the streets across the country, including many of us. I had been hearing from my friends at home and abroad over the last few months, where is everyone? Where is everyone? And I said, don't worry, they're coming. And so it's absolutely vital that people not count on lawyers to solve these problems. We'll throw some sand in the gears, but we're going to need people in the streets to heal the politics of this country. And let me just repeat AJ's encouragement for those of you who want to do more than just go out there, but want to learn a little bit more about how to lead activism. I'd encourage you to sign up for our People Power training series, which starts again July 8th at 8 p.m. Organizing to Protect Democracy, and you can learn how you can take and lead action in your community. The URL again is aclu.org/pp series.
Thanks, Ben. Chase, let's go to you next.
Well, so, thank you, Ben, for that. And I definitely encourage folks to get involved. When I think about what next and what are we all going to do, I think about the fact that I've had the good fortune of being educated and supported by LGBTQ elders who survived and thrived under even more precarious conditions than we face now. And what I learned from them and from the work is that no victory is a complete victory and no loss is a complete loss. And we change the future and improve the lives of our communities by using every tool at our disposal. So we organize, we advocate, we litigate, and I think perhaps most importantly, we look out for each other and we care for each other. One of the most beautiful lessons from queer history that we are going to continue to teach in schools is the way in which our community has cared for each other and for those around us. And so moving forward, I hope that's the lesson that we build together, broad coalitions to fight back against those that would seek to divide us and to make our lives smaller.
Yes. Cecillia, let's go to you next.
I have two thoughts to offer. The first is, we've been talking about the Supreme Court and some of these disastrous decisions and a mixed record with good decisions too, for the last hour. And I want to say this, let's put the Supreme Court of the United States in context. That court takes fewer than 60 cases a year. And there are tens of thousands of cases brought in the federal courts of the United States every year. Not to even mention cases that are brought in the state courts around the country. And so keep in mind that the Supreme Court reaches such a small percentage of the cases that we bring. The ACLU has brought 66 lawsuits so far in the second term of Trump's presidency. And in the cases where we have sought some kind of preliminary relief from a lower federal court, we've got over a 75% success rate. And I hope that that can help people to put the whole hour and the whole term in perspective. The second thing I want to say is really to piggyback on both what Ben said and what Chase said. When you are an ACLU lawyer and you're defending civil rights and civil liberties, so often, most of the time, we are standing up for people who are a minority, who are members of a marginalized group that is politically unpopular, and that majorities of state legislatures and that majorities in Congress want to pile onto. And when you do that work, defending minority rights against a majority will expressed through state legislatures and other policymakers, this is really lifelong intergenerational work. I started out as a civil rights lawyer focusing on immigrants' rights work in 1997 at the ACLU. And we were fighting a 1996 immigration statute that Congress passed and that Bill Clinton signed into law. We are still fighting to restore constitutionality and due process in the immigration system. And those fights carry through out all of our issue areas at the ACLU. So take heart. This is lifelong work. This is the work of many generations and many lifetimes, and we will keep at it. So please stick with us.
Thank you for that, Cecillia. I was thinking so much about the leaning on the teachings of our elders, like as you'd mentioned and Chase has mentioned before, and thinking about the folks who brought me up in an activist community and the things that they have seen and they have gone through, and the lessons that they have taught us. And I turn to those every single day. I want to remind us to always be in community with one another. As Ben lifted up, we saw exactly that as people flooded the streets all across this country for the No Kings protest just weeks ago. We are always each other's keepers. And so we have to keep that in mind. Let's also remember that there are so many cases that are going on around the country that are outside of the Supreme Court. And as Cecillia said, our success rate is 75%. That is nothing to thumb your nose at. We are absolutely, we are kicking butt, we're taking names, we are winning, which is absolutely incredible. But what I'm really holding is something that I remember, words from Cleve Jones, who's like the founder and creator of the AIDS quilt. And he had some video remarks when we did our Freedom to Be event in Washington, D.C. in May. And he talked about, of course, the moral arc bending towards justice, but he gave that reminder that we have to be the ones that bend it. It does not bend on its own. And so as we move through the days ahead and things continue to be difficult for us, we have to continue to remember that we are the ones that save us. The power of the people is always greater than the people in power. We save us, we bend that arc. We have to be able to count on one another. And so I thank you all for being here. I thank you, Cecillia, Chase, Ben, for being in conversation with me. And of course, I thank everyone who joined us today. Never forget, we have each other's backs. We're not stopping, we're not going anywhere. You all, as our ACLU supporters, are essential partners in this fight. We could not do this work without your continued support, your engagement, your activism. We are so deeply grateful. So thank you so much for your support. Thank you for listening and being in conversation with us. And please take very good care. Until next time.